Major breaking news. The United States Solicitor General's office under Joe Biden has sought certiorari in the case of Vanderstock, which deals with the quote-unquote federal ghost gun rules. This is going to be the next Supreme Court case touching on guns next term, almost certainly. The Supreme Court has not decided yet, but if the Solicitor General's office is asking for this regulation that has been declared unconstitutional and illegal by the United States Court of Appeals for the Fifth Circuit down there in Louisiana and Texas, it is almost a certainty that the U.S. Supreme Court will grant cert and hear the Vanderstock case over quote-unquote ghost guns. Stay tuned. We're going to break down this major filing just filed right now by the United States Department of Justice. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Keep and Bear Arms. Major news coming out about new books and articles very soon, but for the moment, check out Disarmed. All right, folks, major breaking news. This is important, very important. This is the next Supreme Court case touching on guns in America for the term of 2024-2025. That is the Vanderstock case against Merrick Garland. This is the quote-unquote federal ghost gun rules. Six attorneys for the United States Department of Justice, paid for by your tax dollars or by the printing of money, filed a major brief today seeking a ruling from the United States Supreme Court to hear this case, grant cert, and override and overrule the decision by the United States Court of Appeals for the Fifth Circuit that said that the ghost gun rules, which, as you know, is a political propaganda term by the left in America to try to go after do-it-yourself guns, homemade guns, which is a long-standing American tradition going back to long before we were even a country. And in this Vanderstock case, which we won below in the U.S. Court of Appeals for the Fifth Circuit, the Department of Justice is trying to overrule that decision and have the Supreme Court overturn it and allow the quote-unquote ghost gun rule to go into effect, which it technically is in effect right now, by the way, even though it's been declared illegal, and that the ATF acted by expanding the scope of what constitutes a firearm under federal law to beyond the scope as defined by the Congress. 6 attorneys, including the Solicitor General herself, Elizabeth Proligar. Now, you remember Elizabeth Proligar because you heard a lot of her arguments made in the Rahimi case. I played a lot of those arguments, and you heard her quite a bit. She is the lead attorney on this. Put her name on it along with 6 attorneys. 6 attorneys are coming after our gun rights on behalf of the Biden administration in the U.S. Supreme Court. Now, the Supreme Court does not have to grant cert in this case, but they almost certainly will do so. The United States Solicitor General's office is full of excellent lawyers. And they bat something around 80 to 85% as a general matter when they seek cert from the U.S. Supreme Court. The Solicitor General has historically been referred to as the 10th Justice. And what that means is because they're so important in signaling what cases should and should not be taken by the Supreme Court, they function to a large degree as the 10th Justice, metaphorically. Thank God they don't get a chance to vote, or Elizabeth Proligar would vote all of our rights away, but set that issue aside. That's just my view. But anyway, with respect to the Vanderstock case here, the court is almost certainly going to grant cert here. This is the case you may recall that went up twice on emergency applications where the Fifth Circuit had enjoined the rule and then they vacated the rule nationwide because they said that the ATF, when they promulgated this ghost gun rule, lacked the authority under Congress to expand the definition of firearm. And just to jog your memory, under the Gun Control Act of 1968, there are certain things that have to happen. Specifically, if you sell firearms for a living, for money, you have to register, you have to get a license known as an FFL. There's different kinds of licenses. We don't need to get into that right here and right now. But the bottom line is, if you want to sell guns, you have to get an FFL as a general matter if that's your business. Okay? So in 1968, the ATF went out there and defined firearm and talked about how it's a frame or receiver. It was not specifically defined what a frame or receiver is, but we understand that a frame is basically the frame that goes into the basics of the handgun, where the relevant parts attached to it. A receiver, of course, is the basic gun, basic part of a long gun or a rifle, of course, where the other parts kind of attached to it. That's a simple way to understand this. The reason why a frame or receiver's definition is so important under federal law is because it is the frame and the receiver upon which a serial number is to be attached, for one. And number two is, if you sell a frame or receiver, that constitutes a firearm. And what's going on here is that you have people are making parts of frames and receivers. They're making parts or selling parts of firearms. And what Joe Biden wants to do is to expand the scope to make sure that everyone that sells parts of firearm parts, incomplete frames or receivers, incomplete parts of a firearm, and somehow they want to expand this so they knock out the do-it-yourself ghost gun, the do-it-yourself project, home project firearms efforts, guns, I should say gun parts. They want to expand the scope and make it harder and more expensive to do any of these firearms-related activities. That is the entire point of this Biden administration, is to put obstacles and sand in the gear and to effectively, through regulation, tax everything there is associated with firearms in this great country. That is the goal. And this ghost gun regulation, which again is a propaganda term for simply do-it-yourself homemade guns, which people have been doing since we were before a country. We know that. And nevertheless, that's what this is about. The Department of Justice lost in the U.S. Court of Appeals for the Fifth Circuit, but as you may recall, the injunction and the vacatur decision went to the U.S. Supreme Court twice, and in a 5-4 decision, as I recall, Justice Barrett and Roberts sided with the three liberals to allow the quote-unquote ghost gun rules to go into effect. Even though they were declared to be unconstitutional and illegal, they are effectively the law of the land because they've neither been enjoined nor have they been vacated, because the Supreme Court essentially says that that cannot happen unless they weigh in on this, or they choose not to weigh in on this, and then they let the lower court ruling stand. That is not going to happen here. The Supreme Court is almost certainly going to take this Vanderstock case. Now, I should mention to you that the two questions presented in this case by the Supreme Court, or I should say by the Solicitor General to the Supreme Court, are as follows. The first question presented, according to the Solicitor General's office, is this: whether a weapon parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive is a firearm regulated by the Act. The second question presented, according to the Solicitor General's office, that they want the court to take up and hear and decide is, quote, whether a partially complete, disassembled, or non-functional frame or receiver that is designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver is a frame or receiver regulated by the Act. Now, you know and I know that it's going to be very difficult to persuade the U.S. Supreme Court that the definition of frame or receiver should be broadened to some newfangled definition that was just made up by the Biden administration. I think that the Supreme Court is on the verge of knocking out the Chevron doctrine, which, of course, is in the Loper-Bright case. I think they're going to rule in our favor this term on the bump stock case, which I know that that's not the hottest, sexiest topic out there, but winning on bump stocks will send a message that this Supreme Court thinks that the Biden administration's regulatory overreach has gone insane, and that if they want to regulate firearms in some way at the federal level, the right answer is to go to Congress and pass a law and play it out that way, and not have what we have now in the White House, an emperor with a pen and a phone, a la Barack Obama, thinking that he can just do whatever he wants. Now, I should also mention, there's a news story this week that you may not have seen that touches fingers with this issue involving Vanderstock, although it's not obvious, but I'm here to make you smarter than anybody else in that room. And that includes the federal judges that are in that room, by the way. Okay? So even though the Supreme Court said that Joe Biden's regulatory efforts last year or so, you may recall that, to try to give a student loan giveaway of something like, I don't know, it was like $600-700 billion. Needless to say, Joe Biden wants to forgive student loans, but he has no interest in forgiving home mortgages, credit card debt, or anything else. He's only interested in student loans because he thinks a lot of the people that got student loans but weren't able to pay them back are public, quote-unquote, public servants, also known as government workers, teachers, people like that, who are really the core of Biden's base. If you think about some of these public school unions, these public school teachers, at least I think that's the strategy. People that work for the city of New York, people that work for these cities like D.C., all of D.C. basically works for, in one way or another, for the government. So I think that Joe Biden viewed this as a way to, give money to his base. Obviously, that was the plan. But the U.S. Supreme Court said that Joe Biden lacked the constitutional authority without Congress's sign-off to simply wave a magic wand and to forgive almost whatever it was. I literally think it was like $600 billion in student loan debt, some crazy number like that. But the Supreme Court says no can do. The reason why that's important is that this week Joe Biden was literally bragging about they found workarounds under other programs to give money away to public, quote unquote, public servants. It's kind of ironic word, public servant. Nevertheless, that's the way the statute was written. And then he's bragging about how he got around the Supreme Court, even though they tried to stop him. Now, of course, the Supreme Court is not going to be ignorant of this. That will be brought to their attention that the Biden administration, start to finish, has been nothing but trying to get their own way without having to consult with Congress. And this Vanderstock case, I think, is going to be another situation where I think the Supreme Court is going to have an opportunity to slap down the ATF. So with a little bit of luck, and I do think, now you may ask me, do you think Barrett and Roberts are going to rule the right way, given the fact that they denied they basically allowed the injunction or stopped the injunction from going into effect, which meant that the ATF's regulations on these frames and receiver rules were allowed to continue in effect and shut down a lot of people. And I think, I don't think that speaks to how Barrett and Roberts are going to rule on the merits of this case. I think this is a very, very strong argument in favor of the Second Amendment community, in favor of the ghost gun industry, whatever you want to call the do-it-yourself industry here for firearms. I think we will win this case. Ultimately, it will be another black eye to the ATF. So if we're lucky, in the next 15 months at a minimum, we should have the following victories under our belt. I think the Rahimi case will come out that says that only dangerous people can be disarmed, which is a good ruling for us. I think the bump stock ban will go away. This case involving Vanderstock, the quote-unquote ghost guns, will be granted cert, and I think we will win that case. I also think the Chevron doctrine and Loper-Bright will go away. I think these will all be major victories in support of the Second Amendment, even if they're not technically Second Amendment cases, with the exception of Rahimi, because this is all going to cut back dramatically on the authority of the ATF to do all sorts of nonsense. And then, of course, the election's coming up, and we'll see what happens there. That's a whole separate topic, of course. And last but not least, don't forget that I think right now, if you force me to bet, I think in 2024, 2025, that Supreme Court term right now is going to have at least two gun-related cases that I can see. One is this Vanderstock case, which the SG is seeking cert on. That will almost certainly be granted cert, is my guess. And the other cases, I think it's going to be something like the Reese versus ATF case out of the Fifth Circuit, which deals with 18 to 20-year-olds and whether or not they have the right to keep and bear arms under the Second Amendment, or can they be deprived of, for example, the ability to acquire handguns from an FFL at the federal level, or some of these state law bans involving 18 to 20-year-olds not being able to buy, for example, semi-automatic rifles and so on and so on. Bottom line is, I think we're going to have a good year here when it comes to the Supreme Court and our gun-related rights. This is the next step. By the way, if Merrick Garland and Elizabeth Rolliger did not seek this cert right now, then what was going to happen is the Fifth Circuit ruling was going to go into effect, and that would have knocked out the quote-unquote ghost gun regulation for the whole country. So Merrick Garland and Elizabeth Rolliger obviously are going to the Supreme Court to try to continue that and try to win this. I think the court will grant cert, but I think ultimately we will prevail, and it will be another win for us. But it's an ongoing slog here. Obviously, the Biden administration is trying to slow things down. We've talked about this before. That is the plan of the anti-gun left. They want to slow things down, change the composition of the Supreme Court at some point. That is their ultimate goal, and I think there's a lot of anti-gun judges in America that are playing into that hand. That's my guess. But nevertheless, let's keep our fingers crossed. They grant cert in Vanderstock and we win this case. I think we will, because we won in the Fifth Circuit. I see no reason for five. I actually think it will be a 6-3 victory in our favor, but only time will tell. We'll keep you informed as things progress. And there you have it. All right, folks, hope you learned something here at the Four Boxes Diner. Make sure you subscribe. Follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.